Welcome everybody to the third and last panel of today's launch conference. Before plunging into the issues this panel is supposed to deal with, under the heading Internal versus External Perspectives on International Litigation, let me do what I feel I should do, that is to say, express my warmest wishes to Elaine of success as co-director of the Max Planck Institute here in Luxembourg, where I am lucky enough to be a guest. I'd like also to express my gratitude to her after all these years. You have to know that in the second part of my 20s, I had the privilege of being one of her PhD students. In fact, one among many. She taught me many things, but almost nothing, however, about how a panel like this one should be chaired, with all those high-level panelists, the armchairs, the microphone pressing on my cheek, not to mention the distinguished audience before which all this is taking place, and a wonderful building. So please bear with my clumsiness as I try to interpret my role as unobtrusively as practicable. I haven't got the panache of a TV celebrity, even though I may try to play the role like one of those servants would do in the famous English TV series Downton Abbey, save for the accent. Anyway, I'm sure that the brilliance of the panelists will compensate this depressing shyness of mine. I'll confine myself to ask three broad questions to the panelists, sticking to the outline you find in the conference pack. So you can call it a no-surprise approach. But allow me a very short introduction to this general theme. As the outline clarifies, the dichotomy internal-external should be understood broadly as referring to a question of status, not in a formal sense, of course. In a way, we are squarely in the field of sociology here. International litigation is a social space or a field, to use Bourdieu's terminology, a space which has some structure, some ordering, which justifies that a distinction be made, to begin with, between insiders and outsiders. Of course, I'm oversimplifying now. Within this very same perspective as the outline suggests, we can imagine the existence of more than two groups, even more than three. A whole range of concentric circles, more or less distant from a center, represented by a given jurisdiction or its judges, even though, as one of the speakers, if I'm well informed, is going to argue, even the judges may find themselves playing the role of outsiders sometimes. This is to suggest that the space of international litigation is not necessarily an orderly one. Quite to the contrary, it may allow for strange social architectures, if not Escher-like trompe-l'œil. The fault lines between the different regions of the social space may be blurred, and they may also be interrupted by, let's say, revolving doors, capsules. Having said that, by way of introduction, my three questions, or rather groups of questions to the panelists, will be, first, is this spatial dichotomy, internal-external, any useful in thinking about international litigation? Is it a productive theoretical framework of analysis? Is it sound theoretically, in a word? Secondly, if the first question is theoretical in character, let's say, the second will be empirical or descriptive. how do you see that space, the social space of international litigation? How do you construct it in the light of your experience and studies as practitioners and or academics? Who are in fact the insiders and the outsiders, and how many categories of them do we have? Thirdly and lastly, the third question will be normative in character. Is the way in which the social space of international litigation is currently structured satisfactory from a moral, political point of view? Is it legitimate in a way? If it is not, how should and could be reformed? I shall say that the speakers are not bound to treat this question in all their breadth, of course. They can confine themselves to a single subfield with which they are particularly familiar, or to a specific issue or subject matter. I propose, as a matter of method, to have 3 quick rounds of answers in alphabetical order. And then the floor, or rather the living room, will be open for the audience to speak. Following the example of Judge Simma, I'm asking the panelists to introduce themselves without making that compulsory, since they are well known, and for people like me, as you may have noticed, there are the nice screens all around with the short bios. I kindly ask then Professor Yves Daudet to take the floor and to express himself on the theoretical question. Is the internal-external dichotomy useful, theoretically, in your view?
Well, thank you. First of all, I should say that I deeply regret that my name is not Zoe. But anyway, first of all, I would like to thank Helen for the invitation. I am extremely glad to be here and extremely impressed by her career, what she has done, what she will do. We know each other for a long time. If I am right, the first time we met was long, long ago. It seemed yesterday when looking at you, but long, long ago when looking at me, on the occasion of an external program of the Hague Academy in Abidjan, in Ivory Coast, long ago when Ivory Coast was a prosperous country. And then we were together in Paris one, and then our paths were different, but we remain extremely close. And I think that it's due to your friendship that I am here more than to my competence, especially when looking at this first question, as well as the others, in fact. I have to say that I am not a philosopher, I am not a sociologist, maybe I am a jurist. I'm not sure. External, internal, about international litigation. I was thinking of what does an international litigation mean for the parties, for looking at the case itself, and what is it looking at the effect that the case may have in the future, or regarding backwards, as a precedent, which is, of course, a rather classical and not very original way of thinking. If I am looking at my very modest experience of ad hoc judge at the court and speaking under the control of Bruno Simma, the feeling I have is that the court, of course, happened to deliver obiter dicta, but not so frequently. And I think that the court sticks preferably to the object of the question which is raised in front of her, and has in mind what I would call, but I am not sure it's what you have in mind yourself, but what I would call the internal effect, in the sense that the court is interested in solving a judicial question which is put to her. Of course, judges are eminent jurists. They are interested in international law, and they suppose, and I think they do like international law. They are not opposed to think very clever things about international law, but as far as I've noticed, they do not want to put that into judgment. And I think for a very simple reason, but I would be interested in checking if I am right or not. But for a reason which seems to me to be obvious, it's just wise to do so. And it would be dangerous to answer questions which are not asked, or to elaborate with no use on questions which are put. That is not its role. Well, of course, you can think of the dissenting opinions, dissenting or not opinions. And everybody knows in this room that there is now a judge who is highly specialized in opinions and who delivers extremely long opinions, much longer than the judgments themselves. And one day he told me that, I suppose it's not a secret, because he was joking, of course, telling me that, the hearings are starting, I start writing my opinion. And I told them, well, as far as I understand, your problem is, will the court dissent to you? That's the point. Well, and of course, it's interesting to note that this judge is a former professor. And I think it must be taken into consideration. And I think that the opinions may be a good opportunity to go a little bit further than the judgment itself, but not too far. Remember the position taken by Sir Percy Spender and the South African case, Southwest African case, when he said, I quote but just my memory, an opinion but must remain in close relationship with the case. You cannot deliver an opinion which would go much beyond, much further than the case itself. It must keep a strict link with the case, otherwise it is no longer an opinion, it is something different. And even if I regret the casting vote of Sir Percy Spender, and I would have preferred that his casting vote would be the reverse, but apart from that, I think that he was right in expressing these views about dissenting opinions. And then dissenting opinions have some external effect, which would mean that a judgment plus dissenting opinions, which of course are always something very interesting for someone like me who comes from a civil law system, where, as you know, in the French system, for example, there is no dissent, no opinions, and nobody knows after which votes the decision has been taken. You don't know if it's unanimous or not. I think that for French people it was really always rather exciting, and I have to confess that several times it happened that I read a judgment, I was convinced by the judgment, and then you read a good opinion, and you say, well, that's true, it's not bad, and you feel a little bit disturbed by this opinion. So I am not sure that I have rightly answered your question, but it was a way, maybe it's not the right way looking at Bourdieu's opinions, but it is a way to speak about internal and external.
Thank you very much. If I got it right, you were, among other things, arguing that some dissenters put them in the position of outsiders. The next in line is Professor Hammond. You have the floor.
Thank you very much. And although we're already pretty far into the conference, I'd also like to take a few moments to address Allan directly. First of all, because I'm very, very happy to be here, but also very honored. Most of you have no reason to know this, but I met her already a couple of years ago, but when I was a student. And I had already a few years of law behind me, which I pretty much hated, until I discovered international law, and then international economic law and WTO law. And with WTO law came Allan. And I've always been pretty convinced that if you like a subject, it depends a lot on who teaches it. So I was also very happy when she took me on as a PhD student, which I completed a couple of years ago. And since then, so we've both moved on, and we've actually even moved away, you here and me to Strasbourg. But I'd like to, although we moved on, say something that Gabrielle Marceau said this morning and that I really liked. She said, I don't know about how much I contributed to what you became, or what you are today, or where you are today, but I know what you contributed to me. And there is teachers who really make a difference, and then there's the others. And Allan, you're not the others. So, but now back to the external, internal question. So the first question was, is it useful to think about international litigation? I'll give a very straightforward answer to that. Well, I suppose yes, if only to get the whole picture. So is it a productive theoretical framework of analysis? I've been thinking about that since I saw that I was supposed to be in this panel, and I had no real idea. I had intuitions about external, internal, but no real foundation for it. And so then I took simply the abstract for the conference program, and I looked at the categories that were constructed here, that were the qualifications that were used, and I started to play around with them a little bit, and in the end, I realized that everything depends on what criterion you use. For instance, here in the abstract, it says the internal perspective may include the judge, the lawyer, the plaintiff, the witness. So those are pretty obvious people, whereas the external perspective can be that of the media, the scholar, and the international community at large. But with that, I still didn't really know where to go, and I realized that in the end, everything depends on the criterion you use. Because if you use the obvious one, the one of the actual decision making, then the obvious answer is only the judge is the true insider. If you use the criterion of who is the decision legally attributed to, it's only the judge, and everybody else is on the outside. But that's obviously not the international process, or any process, actually. So then if you use the criterion of participation, active participation in the process, the category gets much wider, because then you have, obviously, all the judge, the parties, the witnesses, the counsels, etc., and the rest is outside. So here we actually do fall back to the categories that are here, that are listed in the abstract. But in the end, if you use even another criterion, which is influence on the decision, that is on the decision-making process, maybe as a whole, not just decision-making, but decision-making as a process, then the category of insider truly inflates, because basically everybody can be put on the inside, and probably even scholars, although I'm not totally sure about that. And that is simply because everybody knows, as soon as you start your law studies, that decision-making or international litigation is not a mechanical applying the law to the facts. There's other considerations. We talked about that in the second panel and also in the first already. There is obviously the consideration of the acceptability of the decision. So obviously any outsider becomes sort of an insider. So the lines are blurry. And in the end, and that is what we talked a little about yesterday, the thing that I found more interesting is maybe not to ask so much who is internal and external, but who is visible in the process and who is invisible. But that already touches on something that maybe I will address a little later.
Okay. Thank you very much. Next is Professor Happel.
Thank you. Again, I've got to thank Elaine for inviting me. When I received the invitation, I thought I really must attend. It's a long way for me to come from the second floor, but had it been even further, I would have been very, very happy to participate. Yeah, insider, outsider. I started off by thinking about judges and academics because I'm an academic, and I'll probably come back to that. But then I thought, who are insiders, who are outsiders here? And I thought of my uncle. My uncle is 80 years old, and I was talking to my mother recently, and she said, "Oh, your uncle, he's been out demonstrating against TTIP." I thought, in a way, I thought this is great. There he is complaining about investor-state dispute settlement. And he probably really is an outsider because he knows nothing about it. But of course, in many respects, I think what a lot of the protesters against TTIP are protesting against is precisely the technocratic nature of the process, the fact that it does exclude the political, so that claiming that the system is in fact fair and that people are simply ill-informed slightly misses the point of their critiques. But I'm not going to talk about that. That's too big an issue. Instead, I am going to go back to judges and academics, because that's really what I know, not about people who don't like TTIP. And I'm sort of fascinated by this on a very personal level, and the personal level is that every time anyone asks me to predict a decision of the International Court of Justice or the International Tribunal of the Law of the Sea, I always get it wrong. And maybe this is just because I'm a bad lawyer. But I can claim external validation. I have been appointed to a chair of public international law. But maybe it's something about what judges do and what academics do that means that what we're doing is very different. And I think there are really three things, and they've already been mentioned. The first is judges are actually interested in the facts. That most cases, I think, are won on the facts. Academics aren't really interested in the facts. In fact, some academics are completely uninterested in the facts. I think, everyone's got some colleagues who say, that's all very well in practice, but does it work in theory? Academics are interested in principles. They're interested in the law as a system, and at a minimum, its internal coherence. That's a very different perspective on dispute settlement. And the second thing is, and I'm sort of slightly surprised this hasn't been talked about more, but it's something that has come up a lot in the discussions that Elena has convened and coordinated on the morphology of judicial decision-making, which is that, particularly in international courts, judicial decision-making is a collective activity. Often, and I think to a rather larger extent than most national courts, we're talking, with the International Court of Justice, even more with the International Tribunal for the Law of the Sea, with these really large benches. And it's already been mentioned, the rather baroque, one might say, working practices that some international courts and tribunals have, in order to come out with the output. And for academics, that's often a bit of a black box, and they don't really consider it. And that's one of the reasons I think academics love separate and dissenting opinions, because, well, frankly, they are often rather better written. because it's one individual voice. There's no need to make compromises to get people on board who might agree with the dispositif, but don't necessarily go along with the very detailed reason that someone might. So, academics have a tendency to have cults of particular judges. Perhaps I shouldn't mention which particular judges. But, that's often, if you look at the influence within a court, people might be, dissenting just because they can't get the votes. And the third point, which is, of course, the really obvious one, is judges and academics simply have very, very different constituencies. Courts are about, providing judgments for, deciding the particular case against them. Primarily, their constituents are the litigants themselves. Academics increasingly are, I think, not lawyers, or rather, they're not just lawyers. They're within a wider university system. When we're talking about insiders, outsiders, they're insiders within their own system. Maybe they're outsiders compared to judges within international litigation. And that very much affects what they think is important and what they think is valuable. Anyway, I've probably gone on too long already, so I should probably stop there, at least for the moment.
Professor Scheuer, it's your turn.
Thank you very much. Let me first of all join in the chorus of thanks, congratulations, and well wishes to Helene. As to the first question, I think a few years ago I would have said this is an entirely irrelevant question because from my perspective, from my area of specialization, that is international investment law, there is no external perspective. Nobody takes any notice of it. There are only insiders. Even when I speak to colleagues, they hardly know it exists. I can still remember the days when even international lawyers didn't know what the acronym ICSID stood for. Things have changed. In the last couple of years, there's been a very developed external perspective. And the interesting part about it, it's totally negative. Investment arbitration ranks almost directly behind child abuse. And there is very little dialogue. I sometimes get invited to speak about investment arbitration and to speak about the various contentious issues there. And when I arrive at these meetings, they're only converted there. They're only the people who are in favor of investment arbitration. The opponents have their own meetings. They don't invite me, obviously. So it's who are the externals? Who are the externalists who speak about it? It's NGOs, it's journalists, it's also members of parliaments, and some states, of course. Incidentally, I can top your story about your uncle. I make monthly payments to my former wife, so in a sense, economically speaking, she should have an internal perspective of investment arbitration. But I can assure you, she has a totally external perspective, which is up in arms against it. She doesn't fully realize the connection between the money she gets and what I'm doing and investment arbitration. But that's neither here nor there. So what are these criticisms of investment arbitration? We hear about secret trials in back rooms, private courts. Now, private courts is something really very bad. The interesting thing is that these people attack investment arbitration, but in a sense, they're attacking arbitration as such. I assume that the journalists who are up in arms against investment arbitration are not really familiar with the institution of international or, for that matter, domestic commercial arbitration. They talk about overbearing multinationals, and they talk about greedy lawyers. Greedy lawyers is a very, very popular image. The interesting thing here, historically speaking, is that nobody gave a damn about investor-state arbitration as long as it was concerned with investors from developed countries, in developing countries, or in former communist countries. That was okay. As soon as it came to the forefront in the context of the TTIP, where the possibility of American multinational corporations suing European states or even the European Union arose, then all of a sudden it became a center of a focus of attention and very much an evil thing. So if you want to really take a really negative view of this, you could even say there is an element of racism there, because it's okay against certain people, but it's certainly not okay against other people. What I also find remarkable is the focus of attention. The focus of attention is not on outcomes. They don't really talk about decisions they don't like, that they criticize. So this is different from the perspectives we heard before. What they are really criticizing is the possibility to sue. So the mere possibility to take a state to court is something that is considered a major evil, not the outcomes. The EU Commission takes a rather ambivalent position in all this. I will be very short. One could talk about the perspective of the EU Commission. I'm not sure if they're an insider or an outsider. I think intellectually they're outside, but in terms of what they're doing, they're inside because they have their hands very deep into this. Anyway, so they take a very ambivalent, if not schizophrenic approach. They are totally against it, intra-EU, so they want to absolutely abolish this for a number of reasons that I cannot discuss in detail here. But they are very much interested in promoting this in an extra-EU context, although they have certain reservations there. Again, I cannot go into too much detail. Let me give you just two examples for the contradiction between internal and external perspectives when it comes to investment arbitration. One argument that you hear from the outsiders, you will have gathered by now that I consider myself as one of the insiders, and I'm not bashful about it. So one of the chief arguments is, why don't you settle this on a state versus state basis like every other decent human being? Look at the WTO, they managed to do that. Why can't you do that? Why do you have to give these multinational capitalists access to international adjudications? In other words, why don't you resort to good old diplomatic protection? Now, diplomatic protection is old, but I'm not sure if it's so good. Diplomatic protection has very serious drawbacks, as we all know. Anyone who's done international law knows that you have to first exhaust local remedies, that it is discretionary, so it's not really very much of a protection if your own home state doesn't like you. In other words, you have to be close to the ruling elites, if you like. Then you have the possibility of waiver. And ultimately, on the international arena, it depends very much on the political circumstances, on the relative power positions of the two states, whether diplomatic protection is successful. So diplomatic protection, state versus state, is not very attractive from the perspective of the investors to be protected. Another related argument is that investment protection generally is all one-sided. It's all in favor of the foreign investors, and it's directed against states, and the states don't get anything out of it. Now, that argument in itself is a bit surprising at first sight, because investment arbitration is only accessible if the states have agreed. Why would they agree if they don't get anything out of it? The typical answer is, well, they were somehow forced. This is usually very vague. The multinationals forced them. As it happens, states have a very strong interest in investment arbitration, and that's also why the main criticism of investment arbitration usually doesn't come from states, not even from developing states, but from some other groupings, typically NGOs in industrialized countries. Now, what are the advantages that states get out of this process? I think the advantage is twofold, if not threefold. I think the primary advantage and the primary motive is that the state actually gets rid of diplomatic protection. For a weaker state, diplomatic protection can be very unpleasant. If you are in a position of a relatively weak state, it is unpleasant to be leaned upon by the State Department, or by the EU Commission, or even by the German Foreign Office, although Germans usually start giggling when I mention that it may be unpleasant to deal with the German Foreign Office, because the Germans always think that their foreign relations are always very pleasant. But this is not necessarily a universal perspective. So, in other words, disputes get depoliticized. They are moved from the diplomatic arena to a judicial arena. Or to put it differently, being sued before an international tribunal is the lesser evil from entering into a confrontation with a more powerful state. Let's not forget that there were days when investment disputes sometimes led to armed conflicts. The dispute between Cuba and the United States, after all, has its roots in an investment dispute. In the 1950s, Britain and France waged war against Egypt because of a nationalization of an investment of these countries, and there were times when gunboats would settle investment disputes. So the first major advantage is the depoliticization that we've mentioned before. The second major advantage is, of course, that it creates a stable legal environment, which is important for economic development. We often talk about development aid, and strangely enough, when people talk about development aid, almost invariably they mean state aid or aid through international organizations. Now, if you just look at sheer numbers, you will see that the official state aid in terms of capital transfers is a minuscule fraction of private capital transfers in the context of private direct investment. So the potential for development that is in private direct investment is infinitely larger than any official development aid. And I emphasize potential. I'm not saying that every investment is good for development. I'm just saying the potential is there, and obviously you have to be selective. And the third and last point I want to make in this context is, which is not yet empirically proven, but some people say there is also a spillover effect in terms of good governance and the rule of law, which also has internal beneficial effects arising from investor demands for proper treatment based on instruments for investor protection. Let me stop here and let's proceed.
So Michael will close the first round of questions, and I propose that after that, in order to have plenty of time to take questions from the floor, we should have just a second round, since the line between the clusters of questions have already blurred, and happily so. I think that would be practical. You have the floor.
Well, thank you very much, Lorenzo, and greetings to Hélène. I think what I owe you are invitations to Luxembourg. This is. I look forward to how you're going to interpret. Firstly, the name of the institute. I see it's now called for Procedural Law, so it's shortened and broadened, perhaps. And Department for International Law and Dispute Resolution. Are these to be read together or separately or as broadly as possible, I'm sure, and in a very dynamic way of interpretation, which we'll expect from Hélène. Like the others, I'm going to ignore your three questions, Lorenzo, and wait for questions from the floor. There's a good tradition of ignoring questions. We do it at the International Court all the time when we get questions, particularly if three come at once. They tend to be ignored. A very interesting procedural issue to discuss would be whether some of these international courts would be better off asking more questions, because it really is very strange. You stand in front of them, you've got no idea whether they're interested in what you're talking about. it really would be good if somehow they could have the courage to ask questions, occasionally even in advance of the hearing perhaps. So that's a procedural suggestion I have. Now, insider, outsider, I'm not sure what this is about, but two particular aspects, I think, of outsiders. One is third states who are not directly involved in the litigation. Of course, they can ask to intervene, and even if the intervention is not accepted, they've usually made their point. But what about a state that is not involved in the case, but then is deeply affected by the decision, because the decision may be very important for the development of international law? My successor at the Foreign Office wrote an article saying states should react to judgments. They should say that they don't agree with them. They should speak up. But of course, that's not what states do, usually. I think the significance of silence can be very great. If you take the arrest warrant case, which was quite controversial, saying that foreign ministers had immunity ratione personae, based on very little, so it was said, though I fully agreed with it. I thought a lot more people should have such immunity, like legal advisors to foreign ministers. But questionable though it might have been, it's been accepted, and states have accepted it, and that's why I think it's become influential in the law. You could say the same with the international criminal courts, Cassese, Tadic, widely accepted by states. And I think what's changed the law is state acceptance of the decision. You could take other decisions which have been strongly criticized, such as Cassese on terrorism. So I think the attitude of third states is a very important outsider attitude, if you like. And then to talk of commentators, it would be interesting to know, we heard this morning or this afternoon that judges do actually read the literature, and they can be influenced by it even though they don't refer to it. And I believe that's the case. But are they also influenced by what might be written about their decisions? Do they care what's written in these far too many journals that exist in the world today? Well, I think they do. I would hope that they do. And they're cautious because they don't want to be criticized in the literature for their judgment. So I think the relationship with commentators would be very interesting. Just a word on your black box project. I mean, I think it's very dangerous to look inside this black box. And I hope you don't find out too much, because there has to be a space, to use a modern word, where the judges can act alone, not being investigated. I hope the judges don't tell you anything about what happens in this black box. I tend to regard it more as a black hole. As counsel, you come up with all these brilliant arguments, and they just get ignored. You see no reflection of it in the judgment. A very recent example is the Law of the Sea Tribunal's advisory opinion in the sub-regional fisheries case, where very good arguments were put forward as to why the Law of the Sea Tribunal had no jurisdiction, no power to issue an advisory opinion. And these were largely ignored, and unexpectedly, not unexpectedly, the tribunal said it had jurisdiction, but it didn't really give much credence to most of the arguments. No doubt, within the black box, they thought about it very carefully, but they didn't put very much in the judgment. And I'll just stop there.
Okay, so let's go straight to our second round, and let's have it a little quicker than before. Professor Daudet, you have the floor.
Okay, thank you. Well, I would like, in the framework of the second question, just underline something dealing with the social space regarding public opinion, medias, etc. And also reactions which can raise regarding judgment which are delivered. Just maybe one point, if I may. dealing with what you said previously, my modest feeling and my modest experience give me evidence, as everybody knows already, that in a judgment of the court you will never find a reference to an author or a comment on anything. Does it mean that the judges don't care about what is written in the literature? I don't think so, but I think that it's not a secret to say that it's not there are no long discussions during the deliberation about what Mr. So-and-so said about such or such topic in the American Journal or in the British Yearbook. But of course they read, and they have their own opinion, but in French I would say le digère. It becomes their own feeling, but they don't quote. And of course they are extremely interested in the comments of the judgment and the reaction of the states. Otherwise, I think that judgment would not be so well balanced in order to try to give something to each party. Well, going back to the public opinion, first, one thing interesting is, of course, there is in the public there is a great deal of interest for criminal courts. Much more interest than for the International Court of Justice. But it's normal, it's the same thing in domestic order. You are much more interested in the newspaper by a crime which is committed than by a matter dealing with the responsibility of a driver or whatever. So I think it's almost the same thing at the international level. What is interesting is probably the effect of new technologies, of the internet. For example, the fact that you can now follow in live hearings of the court, before the court, or the delivering of a judgment. That's something quite new, and I think it's really important. And by the way, I think the internet, the website of the court is good in this respect. Also, it's interesting to see how many lorries with cameras and a lot of instruments, I don't know exactly what they are for, are in front of the Peace Palace when some judgments are delivered. I think that this is something rather new, because the impact on the public opinion of the judgment which are delivered, of course, is now considerable. I mean, huge. As well, and I think that it explains some political reactions which may be taken by officials just in order to, which are made for the public opinion. Maybe we'll say more in some months when a case dealing with this kind of matters will have been solved. In a nutshell, I think all the role of the media, of the and of the TV, etc., is something really new in this social space. I just wanted to, yes, of course, moving back to what Michael Wood said previously about the kind of frustration that the good arguments are not, well, that's the problem of the judicial economy, which I think is something very, a great temptation. Well, thank you. I stop here.
Andrea.
Well, talking about insider and outsider seemed kind of amusing to me in the first place, because I'm probably the most outsider that there is. First, because I'm a scholar, a pretty fresh one to that, and I've never even come close to actual litigation. So I'm, as far as talking about outsider goes, I'm really it. But this is also a very comfortable position and annoying, because although I'm utterly outside the process, yet I get to question it. And they're going back to these, to the two categories I identified earlier that I said maybe merit some attention, visible and invisible. Something came to my mind when I thought about this external internal perspective, and I will just quote two little parts from a judgment from the International Court of Justice and one from the WTO panel. The first is from the Pulp Mills case. It's pretty brief. The court observes that a post-operational average value of 3.8 milligram per liter for dissolved oxygen would indeed, if proven, constitute a violation of CARO standards, since it is below the minimum value of 5.6 milligram of dissolved oxygen per liter required according to the CARO digest. Okay. However, the court finds that the allegation made by Argentina remains unproven, and then it goes on to explaining why. So by comparison, in the WTO, in the biotech products case, the panel says that it has previously noted that the term pest encompasses plants which are destructive or which cause harm for the health of other animals, plants, or humans, etc., etc., etc. So both of these cases, like many, many that international courts have to adjudicate today, touch on matters that are highly scientific in facts. But there is one massive difference between both cases. It's in the first case, in the one before the ICJ, as far as I know, experts were utterly outside the process, at least officially, while in the WTO, they actually use experts. Whether they always do it wisely is another question, but they use them. So that got me thinking about whether to some extent there are not cases where judges are actually, I will use the provocative phrase, outsided by the facts, simply because the people who really understand the facts would be the experts who are not always brought into the process. And so that got me thinking about who are the experts when they are part of the process. And there are actually, two categories of visible experts, which are the ones that are appointed by the parties, and courts are not always very happy about them, and they take their opinion carefully. And then there is those that can be appointed by the courts themselves. And I obviously don't know about all international courts, but there the practice of the ICJ is quite strange. The ICJ does not appoint judges, and it got me thinking. Appoint experts, and it got me thinking about why. And I could think about probably three reasons. There might be more why they don't do it. The first might be that it's about the judicial function. They need to give, at least towards the outset, the impression that they are really the ones who stay in charge of the whole process and get the whole picture. The second might be that, in the end, an international court is supposed to settle disputes, and sometimes expert opinions can be annoying that way. They might not serve the purpose of actually settling the dispute in a transactional way. And the third argument I thought about, which might be true for the ICJ, I'm not sure, is that, experts cost money. And the experts that are appointed by the parties, they will be paid by the parties. But I suppose that the experts that will be appointed by the ICJ will be paid out of the budget of the ICJ, which I suppose is not that massive. So those are the two categories of visible experts. But then there's obviously the invisible experts, which were actually pointed at, I think, in the Pulp Mills case. No, not the Pulp Mills case. In the Pulp Mills case, the ICJ was not very happy about another category of experts, which would be the expert counsel, meaning the delegation actually puts as counsel somebody who has a scientific opinion. But then there's the invisible experts, and I would suppose that they have a huge role. And there you have real issues of procedure behind it, because obviously expert counsel and the invisible experts never get cross-examined. Although cross-examination should be part of the process for court-appointed experts and for party-appointed experts. So, so it often starts with a procedure issue, but actually behind it sometimes, often creeps up a really systemic issue, because I suppose what is behind it is often the question of whether it undermines the authority of the court, but in my opinion, it would not undermine the authority of the court to have recourse to experts. And on the contrary, it would probably even enhance it. But I think I'll stop there.
So, if I may interject, so you suggest, as did Judge Simma, for instance, that the ICJ takes its cue from the WTO experience, using experts in the same way that they do in Geneva.
Yeah, for instance, yes. I mean, in the WTO, I started to get interested in litigation by examining the WTO, and for quite some time, I actually thought that what is going on in the WTO is common sense, because it was the only thing that I really knew. And then I realized it's not common sense is not that common. But yes, why not? I mean, the only difference is that, and that makes a real difference, is that in the WTO we have an appellate body who says when it's not happy with what the panel did in terms of standard of review, etc. So that obviously does not exist in the ICJ. But yes, why not? Why not be inspired by what the WTO does in regard of experts? And all the rules, the same rules regarding expert recourse exist for the International Court of Justice.
Thank you. Matthew, you have the floor.
Yeah, thank you. What is this space? It's always more fun, I think, to be with most people. I think would rather see themselves often as at the moment as outsiders rather than insiders, with some distinguished exceptions. Interestingly enough, we've just had in the UK an election for the leadership of the Labour Party, and everyone was saying, "Hey, I'm not part of this political class. I may have been." I may have been taught at Cambridge, I may have worked for being a minister's advisor and then a member of parliament and then a minister, but hey, I'm an outsider, I'm an insurgent, and it didn't work for most of them, I have to say, because I just take the view that, that some people are more insiders than others, but there is, and it's a fairly disparate group of people doing international law jobs. But I think we're all insiders compared to an enormous number of people out there who have no idea whatsoever what we're doing and find it quite threatening at times, which is, I think, what we're seeing with investor-state dispute settlement. And I think it's also interesting, this distinction between lawyers and experts. I mean, we are experts in our own field, of course. And in fact, what lawyers do is technocratic in the same way as what many other experts do, I think. And in fact, that's I think, in many respects, the problem is that it may, changing moving the decisions away from lawyers to experts probably won't assuage the disquiet a lot of outsiders actually feel about what's going on and how decisions are being taken. And I think, we're seeing this with investor-state dispute settlement. There's a real there is a crisis of legitimacy. Legitimacy is ultimately about perception. It doesn't matter. Well, it does matter how accurate it is. It matters for us. But I think for a lot of people out there, they just feel alienated from the process. And maybe we should worry about that happening with other courts as well. I was reading some interesting empirical work about courts in England and Wales recently. One of the things is if you question people about what judges do, by and large they think they're out of touch, liberal, they let criminals out of jail, etc., etc. Then when you talk to people who've participated in the criminal justice system through participating in juries, 90% think judges are excellent. So, when people are involved in the system, they tend to be a lot more positive than when they're not. How we do that, though, that's beyond me. That's the third question, isn't it? And I shouldn't go there, perhaps. So maybe that's a bit provocative. Can I just say one thing about literature, though? I mean, I think this is really interesting. You know, there's a number of distinguished US judges who've basically said, we don't read what academics say. It does, because it doesn't reflect our concerns. Now, I think, you know, Michael, you made the point, there are more and more journals of international law. You know, and I regularly meet people who say, what we really need is another international law journal. I always think, no, we don't. You know, we've got loads of them. I can't keep up with it's far too many. I can't keep up with the literature. Why are there more? And it's not. It's because most academics are addressing an academic constituency, and actually they're not really worried about whether judges read them or not. There are some that are, and there are some that aren't.
Professor Scheuer.
Andrea, you mentioned that you're a complete outsider. Well, that may change one day, and it could change rather suddenly. And once you get appointed as an arbitrator or as an expert, what you're doing now as an academic will matter. In fact, people, before they appoint you, will read and scrutinize what you've written and published in the past very carefully. And I just want to warn you, what you're doing now will be held against you later on. Let me tell you an anecdote about an expert who was, before a tribunal, who was confronted with the fact that his expert testimony was in complete contradiction to something that he had written before. And his response was, when I get paid, I can think much better. Not sure if it's true, but it's a good story. Now, to get serious, the program says something about the making of international law in this context. I don't think we've covered that. One question that has vexed me is, to what extent do pleadings before international courts and tribunals contribute to the development of international law, notably to customary international law? We all know it's accepted dogma that customary international law is made by practice and opinion juris, and in a sense, pleading before an international court can be either or both. It doesn't really matter. But at first sight, it seems highly relevant. On the other hand, if you look at it more closely, before some international fora of adjudication, states essentially farm out their cases. They hand it over to a private law firm, and then it's a lawyer from Washington or wherever who appears before the international court or tribunal and pleads on behalf of the state. In fact, he speaks in the first person. He says, I, the state of Romania, or whatever, and behaves as if this person was the state of Romania. And that's also how it's in the record. That's how it's in the award or judgment. Romania said this and that. Now, to what extent are these pleadings by private lawyers evidence of opinion juris by states? Are these utterances attributable to them? I've asked this question to a number of eminent international lawyers, and I got totally contradictory responses. Some people said, no, of course not. This is complete advocacy. They say one thing one day and another thing the next day as it suits them. Other people at the other end of the spectrum have said, yes, of course. And these private lawyers are always directed and instructed, and they work not only on behalf of the legal advisor of the Foreign Office, but they're also told what to say and what not to say. Not sure if that's true. I rather doubt it. Doesn't fit my experience. But I would really be interested in knowing what you think about it. May I ask the chair, can we take a vote on this? So who thinks that the pleadings by a law firm on behalf of a state before an international court...
That's not sophisticated enough.
Okay, you formulate the question.
Please distinguish between the agent...
Okay. Yes, but that's not... Yeah, I know that you would raise that, but that's before the International Court of Justice and before your Law of the Sea Tribunal. But if you go to the... Okay, the same in Strasbourg. But if you appear before the before an investment tribunal, for instance, and there are major problems of international law, of public international law that are discussed there. There is just the law firm there. There is no agent there, although perhaps an agent is listed but is not really involved. Okay, but if you think that the question is impermissible or wrongly phrased,
whether we consider counsel as a statement of practice,
okay.
you can ask for a vote, I will vote no.
Now don't say, you're influencing the audience. You've spoiled the vote, Rüdiger. Okay, so who thinks that this, and we know what this is?
Can I also ask the question, for example, when you have a tribunal taking into account a declaration made by the agent of the state during the hearing,
Okay,
consider it as a unilateral commitment by the state,
that takes things even further.
and it's a precondition for the decision.
Yeah.
So then,
Yeah, but that's a slightly different question, Elaine, because that's a specific commitment. I was just thinking about general statements about the existence or not of a rule of international law, to put it in very simple terms. So who thinks that sort of thing can contribute to the development of international law?
Yes?
Oh, that seems to be...
I have a cartoon on my office wall.
And who votes against? There are many abstentions.
Yeah, well, I'll tell you why I abstain. I have a cartoon on my office wall, and it has a man giving the speech at a graduation ceremony. He says, when you came here, you knew nothing about law. All you could say, if you asked a legal question, is, I don't know. I don't know. Now, after 4 years of legal study, with all the authority of your legal degree behind you, you can say, it depends.
You could also phrase it different and say, you're just as confused as before, but on a much higher level.
Yes. I'm better informed, but no wiser.
Yeah. Okay,
Let's see.
I'm finished.
What is the...
If,
Absolutely.
Yeah.
Okay, that's a Solomonic answer. Yes.
I think we should hear the point of view of the special rapporteur on
Well-
custom and identification of custom
Yeah,
international law.
the International Law Commission will give the answer to your question in due course. But I very much agree it all depends. It all depends on what weight you give it, how clearly it was stated, but I think states have to be bound by what they've said in court. On the other hand, not in this court, because it's not published. The very strange thing about the Court of Justice of the European Union is that the pleadings, the written pleadings, for example, are not available publicly, are they?
They are after the judgment.
All of them? Okay. But not during the hearing, so no. Right. Do you want...
yeah, but may I? The fact that it binds the state is one thing. The question if they contribute to the development of international law is another thing.
Well, I wasn't saying it. I'm not talking about binding the state. I think it's an element of opinio juris.
Yes, not binding.
Certainly,
but
it's an element of opinio juris, for what it's worth.
Yeah, but it's something different from the development of international law, which was the question which was asked. I think, if I understand
I'm not
the
sure.
question.
The question was very vague. Anyway.
You see, it's why the reason you must not always trust the councils.
And of course, when the court the state turns up in a few years and argues the opposite, it can say, well, the law changed. So,
We
just
were wrong.
2 comments in the second round, because I really want better questions from the audience, or the participants. Firstly, I think that an international court or tribunal, when it's deciding a particular case, should not have regard to all these external things, the media, what's going on. It has to decide it within the confines of the courtroom. The fact that it's televised or streamed or whatever is irrelevant. And certainly as counsel, you don't think about what's going on outside, though I think some counsel do, particularly when it's televised, when it's web streamed. I won't say who. So that's the first point. I think the court has got to be isolated. It shouldn't have regard to outside things. Of course, that's an idealist view, but it should be the aim. Now, the second is this insider-outsider division. Of course, it's long been said that with public international law, particularly in the interstate field, it's a very small group of people, this invisible college, who are directly involved. You could say even more so in the investor protection field, where it's a very small number of people who turn up as arbitrators. I do think that's changing. I think now with so many international courts and tribunals, there's far more opportunity for people now looking forward, and we won't have this very small group of insiders. Whether that will be a good thing or a bad thing, I leave open. Actually, it's bound to be a good thing, but there are those who might say it's not a good thing. And I'm going to stop there because I do want to have questions.
Okay, let's see. I thank you, the panelists, very warmly, with a ever lower tone of voice. Let's see if there are questions or comments better questions or comments from the audience. Please. Is there a microphone?
Of course, we may be keeping people from the drinks reception.
Well, there's 20 minutes for that.
Yeah.
Or they might think that.
Thank you. Thank you for an excellent panel. With respect to outside opinion, and I just want to, I agree with the point about academic commentary. It's often too specialized, too pitched at a academic audience, and there's simply too much of it. But I did want to get your thoughts on whether the bigger development, or with respect to made possible by the internet and blogging, which is often done by people who are formerly insiders and people who are specialists in that particular area. And so whether there's a potential for influence either before, right, because people may be writing while a particular action is pending, and a very specialized, expert opinion on particular issues, or after the judgment, so that that judges will know, and they may not be influenced by outside political pressure in the media, but they're conscientious and they want to get things right, and they don't want to find out they've written something and they got something wrong. And so the reaction, unlike academic journals, is immediate, and it also can be sharp and more critical in academic journals. So just the thoughts on that, which is a relatively recent development, and one that I think is there to stay.
Well, I don't read blogs. I found them very unimpressive. There was one I read which said, I'm halfway through reading this judgment of the International Court of Justice, and I just want to set out what my thoughts are so far. And I thought, well, I'm really not interested what this person's thoughts are so far, halfway through reading the judgment. I think instant writings on the law are not very sensible. They're not particularly interesting. Who needs to know the stream of consciousness of somebody? I prefer to read something that's been thought out than a blog. So I don't read them. And I hope the judges don't read them, particularly if they're about cases they're deciding, which I'm sure they don't.
The floor is to one of the editors of the EJTalk blog.
I am an associate editor of Eagle Talk. That doesn't mean I don't think I wrote that because I'm not sure I've blogged.
Dear. It was Marco who wrote it.
I'm not sure. Yeah, probably. I was thinking it was probably Marco. I think I've blogged far less since I became an associate editor than I did before. I think blogs have a role to play. When Dapo Akande asked me to join Eagle Talk's team, he told me that I should do it out of naked self-interest. He said when he goes to a conference, that's what people ask him about, what he's blogged about recently, and that the number of hits he gets far outweighs the number of downloads of any articles he writes. So you are getting out. Yeah, you're getting out to a wider audience. But I think you're right. They have a role. and they do not substitute for the more profound scholarship that you find in an academic article. I just want to say one thing, though. I one morning got up and heard that Julian Assange was in the Ecuadorian embassy in London. So I dashed off a post and sent it to The Guardian. Comment is free. I was very pleased with myself. I thought I'd raised my profile. 2 weeks later, I got an email asking me if I'd like to advise Ecuador. But had I written on it? And yes, I had. And I said that all their arguments were wrong, so they didn't call me back after that.
Please.
So that, I think, makes your point.
It's a question in relation to this external-internal relationship, and I was just wondering if you could draw a distinction between contentious proceedings and advisory proceedings. And I'm thinking especially at the advisory function of the International Court of Justice, where it seems to me that in these cases the court is in fact speaking more broadly to external actors, but maybe I'm wrong. So I'd like to have your viewpoint about that.
Need to be very careful here.
I
don't want anyone.
Let's take another couple of questions from Professor Wolfrum.
Yes.
Professor Wolfrum.
Is it working? Just one question which I believe has not been touched upon. What do you think of that occasionally counsel appear as arbitrators and later again as counsel? Sure, not in the same case, but is it compatible with the rules that you change or switch between the side of adjudicating and advocating? Just a question mark.
Thank you. Hélène?
I also ask my question. Yes, it has already been touched upon during the past panels, and maybe this is the reason why you don't speak about this, but nevertheless, I will persist in trying to opening a bit, at least, the black box. I'm not speaking about the deliberation taking place between the judges as any judicial decision should be. This is not my point, and this has to be covered by the secrecy. There, I fully agree. But there, you have to see that there are other actors taking part in the deliberation process, and there you don't know what is their exact status. And for example, you have the law clerks helping judges to prepare their positions, and you have the secretariat, you have the registry, you have all these people taking part in a way or another in the writing, the drafting or the writing of the decision. And although the judges are supposed to make the decision by themselves under secrecy, you're never sure that the decisions has effectively been done this way and has not been taken elsewhere before or maybe after, in other terms, by other people who are not submitting to the same obligations and whose competence are not tested the same way. So I think this has to be put on the table because you consider no, but sorry, I disagree. And so, but I think this is a real issue, including in terms of legitimacy, in my view. I mean, we spoke this morning about the Yukos case, and the fact that you had this question: has the assistant of the tribunal been a forced arbitrator? I mean, it undermines completely. I mean, it plays against the award. I'm not speaking in favor of the award or the proceeding. This is not my point. The point is that is about trust in the processes. And so this is why I think that nevertheless we should touch upon this. Who makes the decision? Are the one who have made the decisions the ones who are supposed to make the decision? This is also the question underlying what Andrea was saying. Are not judges sometimes outside of the decision because other one has made the decision instead of them? This is the point, though I would be happy to hear your thoughts about this.
Should we take other... Okay, let's take just another question.
I cannot answer, but I would like to have the reaction more than giving an answer as a judge. But it's a very important issue, this. under the angle of the confidentiality. You said the secrecy of the deliberations, because they may remain secret, and probably the help given to writing in the past kept them secret. May remain secret now, but is unlikely. It's unlikely because during the deliberation in many courts, all this goes on computers. And when it's on computers, it's clear you can't guarantee the privacy, the confidentiality. We had a long discussion once with people from New York when the tribunal closes to destroy all what is deliberation, referring to deliberation, even between judges, because there are memos that go between judges, but this will be illegal at least. It's the authority, responsibility of judges to put something on paper that doesn't matter too much if it comes out 50 years later. But if it is other people that participate in the decision, technically it's almost impossible to destroy. People in New York said, we can destroy everything, but are there backups somewhere else? When I put the question, well, maybe, yes, no, we don't, the answer was not satisfactory. So it may be that even in the short term, something may come out. And then, of course, the delegitimizes is completely a court. So we... you can't destroy, exactly. That's why the question is important, in my view.
So let's have the reaction from the panelists. Professor Wood.
Well, my view is that it is a black box. You can't look behind it. It's the responsibility of the judges who signed up to it, and that's that. Now, what went into it, what help they got, even if it's a three-member arbitral tribunal, you don't know who really wrote it, who influenced it, who was most involved. You just have to accept it is what it is. And now, this question, my answer to your question would be they shouldn't be using computers in that case. But then, of course, there have been cases where judges' own private notes get published in due course because they get discovered, and that's also bad. They should all be destroyed, in my view. Very quick answer to the counsel arbitrator point. I think that it stinks to have counsel one day, arbitrator the next day. And certainly I know quite a few people who have decided very definitely in the investment protection field to be one or the other. And I think that's a very good decision. Another completely different question, which I think you should study at great length, is this very strange to me practice of taking expert advice on questions of international law before an international tribunal, an investment tribunal. I always refuse to do it, not that I'm asked very often, but I think that it is just wrong to give expert advice on a question of international law when the tribunal is meant to know international law. That's a matter for legal argument, not for experts. But the practice is such that in the UCOS case, there may have been 20 different expert advices being given. So I think that's something worth studying in order to kill it off, please.
Other reactions? Professor?
Yes, regarding Ellen's questions, it's a bit difficult because it's close to the secret of deliberations, of course, but you have to take into account that one thing is the preparation of the deliberation, and another thing is the deliberation itself. Regarding the preparation of the deliberations, judges have the assistance of clerks and assistants. I would say it's for each judge to decide to which extent he uses his assistant. Well, I am not in the judge's office, and really I have no idea. As far as I imagine, I hope and I think in most of the cases, it's just an assistance in the preparation of the note and of the deliberation. And I think that's two steps different. But what can be said, because I think that's not really a secret, is that only judges speak during the deliberations. So there is no possibility for a clerk to intervene and to say, well, it's well known that you can read the famous article of Bejaoui, La fabrication des arrêts de la Cour, and you find exactly what I'm saying right now. So that's just a matter of, I should say, moral behavior of each judge. Some bad tongues say that in the past time the judgments were shorter and that they are now longer. But I am not sure that there is a close relationship. And I think it's just bad tongues.
I think there's a fairly obvious reason why judgments may be longer. I think it's called the word processor and cut and paste. I don't say that's the case for the International Court of Justice, thankfully, however, as they don't tend to quote from all sorts of sources. I think the role of sort of non-judges in judging is a really interesting one. You know, it's well known the role that law clerks play in the US in the Supreme Court and the federal courts generally. Perhaps I think it's to a large extent, I think, a cultural thing, depending on what the perspective is on. You know, do you concentrate on individual judges and what they do, which would be traditionally the English view. I was one of the first judicial assistants, as they're called, law clerks at the Court of Appeal in London, and the judges were very, very clear that we were not going to have anything to do with drafting judgments, that our role would be entirely about legal research and nothing to do with drafting. But that's one view of what adjudication is. Another role would be that what you have is a court, and the court is a machine for producing judgments, and the judges are directing that, but they are not necessarily the only people. They are the biggest cogs in it. But you have all sorts of other people, from referendaire to, I don't know, translators even, when you're producing judgments in various different languages. The problem is, of course, we have different legal cultures, and then, lawyers from different legal cultures find themselves faced with situations that they're not familiar with and they don't trust, and it seems to go against what they think is right and proper.
Okay, the very last intervention from the audience by Professor Hess.
Thank you very much. I would like to come back to this distinction between the internal and the external view on international dispute resolution. And we have heard a lot of different opinions on that, but I would like to raise the question again, because I have the impression we have a kind of crisis of international dispute resolution. It is seen from the external point of view quite different from the internal point of view. And the question for me is how to react to that. Sir Michael Wood said, to my opinion quite correctly, don't look at all these blogs, press, reactions, etc. But it might turn out one moment that nevertheless they play a considerable role, and investment dispute resolution might be an example for that. My view is rather a comparison of national judicial systems. And we have similar situations there. We have some member states in the European Union where judges have a very high esteem, and we have others where the judiciary is facing a crisis. Nevertheless, the institution of dispute resolution is in need of an acceptance, because we need this kind of, I would say, social or political service or service of the law for our litigation system. So my question would be, how can we react in such a situation of crisis in the different areas, investment dispute resolution, the International Court of Justice, various international jurisdictions, Do we need more consistency, for instance? Do we better explanations, better judgments, or even some kind of press work, which I appreciate when you look at the website of the International Court of Justice, where much more information is now available. What should we do from the internal side in order to improve the external appreciation of an institution which is, to my opinion, extremely useful and needed?
Okay, let's have a very quick round of counter reactions, and then we will have to close. If there are, and Professor Schreiber.
Okay, 3 quick remarks. Michael, you gave a pleading in favor of separating bench and bar. Yep. In other words, counsel should not act as arbitrators one day. This is all very well in theory, but it's difficult to implement. Very few arbitrators get enough appointments to keep themselves busy. There are a few, and that, of course, then runs into the complaint, it's always the same faces. There should be new faces. Mm-hmm. So it's a question of economic survival for many to keep their normal practice as counsel. Consider the situation where a lawyer gets his first appointment as arbitrator. Is he to drop everything else from that day onwards, not knowing whether he will ever get a second appointment?
In the same field, in my view.
Well, if somebody is specialized in a particular field, getting an arbitral appointment could kill him economically. Anyway, second point, secretary of the tribunal. This is not a new problem. It's come to the forefront with the UCOS award, of course, and it's the challenge. But it's an old debate. I remember a lecture by Pierre Lalive in Paris a couple of years ago, where he was very much against the phenomenon of the fourth arbitrator. I would approach it in a slightly more differentiated way. I think there are certain elements of the drafting of an award where a secretary can be extremely useful and where the activity of the secretary is not improper. For instance, summarizing the procedure of the case, or summarizing the facts. There I'm not so sure any longer. This is already more sensitive. Even more sensitive is summarizing the arguments of the parties. And then, of course, an absolute no-no is the discussion by the tribunal. So we have 4 categories of issues in an award with ascending importance for the tribunal to take an active role and not letting the secretary. But I think we must distinguish between these different parts of an award and discuss them separately. And my third argument concerns the confidentiality of a court or tribunal. I think this is even more serious than we have hitherto thought. And this, I think, has been brought to the forefront by the recent scandal surrounding the Croatia-Slovenia dispute. There, of course, the issue, as it was presented to the public, was that one arbitrator was caught in improper communication with counsel for one of the parties. So far, so good. How was he caught? His telephone was tapped. Who caught him? It was the other party. Why did they tap his telephone? Probably to learn more about the deliberations of the tribunal. They didn't say that. They just publicized that part where that pleased them. But in reality, let's face it, what happened is that Croatia found out how the deliberations were going, that the case was turning against them, and they took this as a very welcome opportunity to say, we are not going along with this arbitration anymore, this is irregular. Thank you.
Andrea?
Yeah, I would just like to say something about the question that Hélène raised. I must confess that I never asked myself that question, meaning who else from the outside or from the unknown participates in the actual decision making. I've always been naive enough, and I actually hope it's true, that the actual decision is made by the judicial body. But what I have been wondering about is what is for real the role of the administrative support structure, like she said, not in the actual decision making, but more in the construction of the legal reasoning that afterwards supports the decision. Because sometimes when you read certain decisions, you notice certain grammar tics, or you notice some case law that always appears. Again, and it got me wondering how much of the judicial reasoning is actually construed, well, outside the judicial body by somebody else. But that obviously is a question that we're probably not going to have an answer to. But
okay, if there are no in extremis reactions.
Yes, just. I feel I have to come back on the Secretary of the Tribunal. I do not intend, again, this is an ongoing proceeding, I do not intend to go to the substance of it.
About this case, it was a matter of putting the case on the table, and what was interesting is that Christophe spoke about the phenomenon of the force arbitrator, and this was about this and not specifically about this.
But you did say that the issue raises the legitimacy of the award, right? I want to be very clear on one thing. This is an argument that's put forward by the Russian Federation. It's not being decided. It will be decided by the Dutch courts. It is totally frivolous when you consider that, I mean, going back to one of the issues that were raised, administrative secretaries are subject to the same rules of conflict of interest. So they are akin to arbitrators in that sense. That doesn't mean that their role is that of arbitrator, they're assisting. And coming back to the black box, it is something that's a matter for the tribunal and the responsibility of the tribunal. You don't know what happened, and nobody else will know what happened in that particular case and that particular tribunal. Now, I just want to be clear on one thing. We should not make a proposal based on an argument that's made by the losing party in a case, which is totally different from what Professor Schroer says about the old story of the fourth arbitrator and whether or not this is something that's proper. But again, I don't want for this to be said that this particular case has been improper to the extent that this is something that is not even decided. It's an argument made by the losing party in a case, and it's probably the argument that they're putting forward the most because it's the argument that speaks the most to people. There's a lot of other technical arguments that they're talking about less. Thank you.
Okay. So I think it's finished now. We have to set ready for tonight's dinner.
Let us back within the topic, inside, outside, and what you said about your aunt at the beginning of
My uncle. My aunt wasn't that. It's very important. My aunt loves investor status.
In German grammar, this has always existed.
Yeah, I would.
In Latin too.
Okay, so I think it's time for champagne.
Bravo.
And the launch of the department. So first of all, of course,
Thank you very much.